be moving on to the third and final question for today's episodes. This one is also from an agent, Bruno, and the agent says, can you please assist them? They state that I am busy working on a lease and both the landlord and the tenant are foreigners. The tenant has a budget of 2,000 US dollars per month, which will fluctuate in conversion depending on our rand, obviously. Her company are paying her rental, and this is her budget. Now, the two questions that then come from this is that, can a tenant, Bruno, pay a landlord into a foreign bank account without implications to us, which is Uruguay to UK? And then secondly, the last question or the last leg of the question is, can our lease agreement be structured in dollars? Bruno?
Sure. So different laws and different issues are going to apply to this question. So we'll try to answer as much as possible. And in each different field, but a person would have to have consideration of each field when making a decision like this. So on a very basic level, can a lease agreement or can any agreement be based on foreign currency versus local currency, rand? There's no issue with that, right? No issue at all. We've done it a couple of times in residential properties and consumer-based agreements. One may find in pieces of legislation somewhere that that the legislator tries to have things in rands in order to keep it simple. But with rentals, I've never seen it. With residential rentals, I've never seen it. And we know for certain with commercial rentals, that is not the case. So to answer the second question, can it be done in a foreign currency? Absolutely, right? You just have to follow the right exchange control processes and report it properly the way that it needs to be reported. Shouldn't be an issue at all. So now to have the conversation regarding the transaction itself. Now, for starters, a question that isn't asked, and I'm just going to answer it very quickly, is the pitting of the value. So remember, a rental agreement is premised on the fact that there's going to be consideration payable for the use of enjoyment of a property. So pitting a certain consideration typically tends to be important, but it has to be determinable. So just because the currency or the value of the rand or value of the dollar fluctuates, or pound, if I'm not mistaken. Well, I don't know actually what Uruguay uses, but I think they said dollars. The value might fluctuate, but it is determinable because there are ways of measuring the dollar value versus the rand. Just because the rent might differ on a month-to-month basis isn't a problem, because in terms of the agreement, if a value of 2,000 dollars was paid or $1,000, then you've complied with the agreement. If you want it in rands, then the person paying the amount needs to ensure that the amount that they actually pay in dollars is equivalent to the amount that you expect to receive in rands. So the wording of the agreement is going to be very important, because on whose shoulders does the obligation fall to ensure that a specific amount is paid? So that's also something to just look into. I mean, it's like completely off topic, or not completely off topic, but as a digression, something like TPN, as an example, is going to struggle with this tremendously, because they're not geared for fluctuating rentals in foreign currencies. So like trying to report this tenant for not paying isn't going to be particularly easy, but I mean, that's just a side note. Now, so that deals with the rental component and deals with the transaction itself. The one thing that's also very important to consider here is the tax consequences. And this is a big one, because we're not considering what SARS is going to now be asking of a taxpayer. So the person receiving the rental income that owns a property in South Africa is a taxpayer. Now, in our law, residents, so a tax residents, have to pay tax on all income received worldwide, and non-residents need to tax on any income sourced from South Africa. Given that this property is in South Africa, it's a given that this is going to be taxed. This is going to be taxed locally. So the fact that the viewer is asking whether money can be transferred abroad from one country to another for services rendered in South Africa. Now, in my mind, exchange control wouldn't be a problem here, but I'm not an expert when it comes specifically to exchange control. But I can tell you that even if the money doesn't hit a South African account right now, SARS is going to be asking for that money because it is income that is derived from a source in South Africa. So any which way you look at it, there is going to be no way that there's not going to be a tax liability for receiving this income, whether it's foreign or local. So that's just something to bear in mind. You're not going to keep this away from SARS if it's paid into foreign bank accounts, and you are going to need to disclose it.
Yeah. So thank you very much there, Bruno. We do apologize for the images keeping still from time to time, but we did get the sound very good, loud and clear. And that does bring us to the end of today's questions and answers, and we will be looking forward to seeing you guys again next week. Thank you very much.
Thanks, guys.
Thanks, guys.